A Theory of Jurisprudence. Introduction. The contemporary domain of jurisprudence in the United States rarely gives sincere credence to the authors of the Constitution or meaningful liberty to their posterity. An honest reading of the Constitution and a delegitimization of affronts to liberty are long past due. The best way to achieve these ends is to employ an originalist interpretation of constitutional text, but with deference to natural law. Originalism and natural law. Originalism interprets text based on the original public understanding at the time that text was adopted. Interpreting text any other way would not respect what the people actually voted on and accepted in the democratic process. Meanings of words should not change until the people vote to authorize the change. A conversation today should not have its meaning changed decades from now just because the definitions of words or the opinion of the public have changed. To do so would be to contrive an entirely new dialogue filled with ideas that are not from the original conversation. A judge's job is to say what the law is, not what the law should be. A legislature's job is to decide what the law should be. A good judge will often make decisions where they dislike the policy outcome. But a judge is a servant to the law, not its creator. An activist or living document approach to constitutional interpretation allows judges to become legislatures by not following the constraints of the text's original meaning. Each time a jurist in this school of thought manufactures a new legal theory, they alter the deal and leave for the rest of us a little less liberty, a little less freedom, and a little less stability. If one wants the Constitution to change with the times, then legislatures and voters need to pass laws and amendments. Judges should not change what the people have already voted on. The other extreme is a strict interpretation that looks only to the text. This approach also fails because it does not address the actual meaning behind the text, but only the text itself. Text is limited in its explanatory value. An example some jurists have given to demonstrate the inadequacy of this approach is to look at the First Amendment. Congress shall make no law abridging the freedom of speech or of the press. A purely text-based interpretation of this provides that non-journalistic handwritten notes and paintings are not protected. This interpretation does not safeguard the broader idea of free expression that was understood to be protected by the First Amendment at the time of its adoption. An originalist interpretation of the Constitution should stand unless there are natural law implications. Broadly speaking, natural law is a negative liberty interest, a right from interference, harm, or constraint by others, where no one else is being harmed, except for self-defense. As the Supreme Court has said in its gerrymandering cases, you know it when you see it. Natural law derives from one's humanity. Natural rights are based on the fundamental ideas of self-defense and self-preservation. People have the capacity to experience suffering, and self-defense is an attempt to prevent that suffering. If a person is engaged in an activity where no third party is being harmed, anyone who attempts to constrain that activity is an unjustified aggressor, and their actions can be rightfully defended against. No government and no democratic vote have any legitimacy in violating natural law. Natural law restrains government from creating laws or acting in certain ways. It does not give the government affirmative abilities aside from the protection of natural rights. Almost no judges or attorneys utilize the theory of natural law in order to override or supplement the Constitution, which can result in the violation of fundamental rights. Take this quote from Justice Scalia.
Now, I believe in natural law, but I believe that in democratic political institutions, it's up to the people to decide what they think natural law demands.
To demonstrate the absurdity of this claim, which assumes that democratic preference trumps natural right, look at a hypothetical. The United States repeals the 13th Amendment and specifically passes an amendment that legalizes slavery in the most unambiguous wording possible. Virtually all judges in the country do not believe in an actualized deference to natural law, so they would have no choice but to enforce slavery as legitimate, no matter their interpretive philosophy. If you were a judge, would you do such a thing? If not, why? If you wouldn't enforce slavery, why not refuse to enforce other violations of natural law? What guiding standard would allow you to reject slavery but uphold other violations of basic human rights? Ownership of people is illegitimate and cannot be recognized by any voter, politician, or judge, no matter what the law on paper says. What right does the government have to violate natural law? Certainly not the tyranny of the majority. If democracy gets to decide what natural law demands, then it's just law. It's not natural law. Supreme Court cases as examples. 1. Roe v. Wade and Dobbs v. Jackson. The United States Supreme Court has both failed and flip-flopped in its abortion jurisprudence. In Roe, The court used the self-created idea of substantive due process in the 14th Amendment to achieve an end that it liked, the qualified right to have an abortion. The court used the Constitution as a catalyst for fundamental rights. While the Constitution does protect a lot of fundamental rights, there are many it does not protect, such as abortion. To protect rights like these, one must look outside the Constitution rather than artificially engineering confused legal theories. Roe utilized the incorrect means to achieve a decent end. In Dobbs v. Jackson, which replaced Roe, the court used correct but incomplete means to achieve a bad end. In Dobbs, the court was correct in saying that the Constitution leaves abortion regulation up to the states, but neglected any natural law implications. I submit that abortion does have natural law implications that trump the mere text of the Constitution, and this is something to be discussed in depth in a different video. Even though other forms of jurisprudence can reach the same conclusion, in law, the means are just as important as the ends themselves. Using the wrong means may reach a good conclusion today, but a horrible one tomorrow. 2. Obergefell. In Obergefell, the court decided that all states must give out homosexual marriage licenses because, inter alia, marriage was a fundamental right protected by the 14th Amendment. The court again interpreted the 14th Amendment to mean something other than its original public understanding. The court used the wrong means to achieve the wrong end. Additionally, natural law was not implicated in a way that would support the court's conclusion. Marriage grants certain rights to people. It is not a negative liberty interest because it is not a right from something. Creating a private agreement with other consenting adults to form marriage-like contracts would fall under the purview of natural law. It is a voluntary association between consenting adults and harms no third parties. Therefore, no government should prevent such an association. However, a government-granted marriage comes with various benefits and privileges from the state, making it something very different. This case is a particularly interesting example because it involves a policy outcome that I find desirable. In a perfect world, the government should get their long, crooked noses out of marriage. Marriage should be a private contract between individuals. Polygamous, homosexual, heterosexual, and any other kind of marriage contract should be allowed so long as it is between consenting adults. If, however, the government remains involved in marriage, I would support allowing marriage for all consenting adults. But as a judge, I would need to say what the law is, not what I want it to be. As a judge, I would uphold the natural right to private marriage contracts, but reject the court's decision in Obergefell that mandated homosexual marriage licenses be given out by the state. Conclusion. The modern conventional approaches to jurisprudence are at best the coronation of mediocrity and at worst the invigoration of tyranny. Sects of originalism used to be orthodox in the courts, and the idea of natural law started to disappear soon after the Declaration of Independence was written. Today, a meaningful application of natural law is rejected by most jurists. Originalism should be the watchword for those wishing to faithfully adhere to the Constitution, just as natural law should be the foundation for those wanting to see liberty. Bodily autonomy, association rights, free speech, and religious freedom are just a few areas where natural law deeply permeates. A natural law jurisprudence would revolutionize things like abortion, drug use, prostitution, economic association, and euthanasia policies in the United States. Laws that violate natural law, whether enacted by an authoritarian monarch or by the tyranny of the majority, are illegitimate. Democracy and originalism are only just and useful tools until they clash with the sovereign dominion of natural law. When the government wishes to revoke natural law, they need to be asked, by what authority do you claim that right? Surely a majority vote is so insufficient an answer as to be insulting. Tell the sheep that he's for dinner, just because he was outvoted by two wolves.